There's your Pear Deck link for this morning. Good morning, Tori. There's this morning's Pear Deck link. Today, we're going to be talking about lesson 4.9, the Warren Court. This is the last lesson of Unit 4. Okay. Just again, a reminder, tomorrow we have the MLK quote analysis discussion. That's part of the assessment. You just have to, read the quote and give me your analysis on it. I gave you sentence stems on how to answer it. You need to use complete sentences. Comment on other students' submissions, and that's just the one part. And then the second part we'll do together on Thursday, and that will be the rest of the test grade. And then Friday, we'll introduce ourselves to Unit 5, and then we'll get rolling on that next Monday. Okay. That's where we are. It's our little bit of housekeeping. And there's that Pear Deck link. You're just joining us. Here we go. First off, where's that stress level this morning? How are we feeling? I woke up feeling good. Got some stuff done early. Just kind of mapping out the rest of my day. So I think I'm at about a 3. I think I'm at about a 3 today. I gotta keep a little bit of stress on me. No pressure, no diamonds. Man, we got a couple people on this side. Couple. I think more than ever over here. Oh, I think one of those is me, actually. I'm sorry. my bad. But if you're over on this side, guys, if you're in this 6, 7, 8, 9, 10, and there's something I can do to help you out, to help bring your stress level down, please let me know. Okay. If it's regarding grades, again, I can come up with an assignment list for you. I can tell you what you're missing, what scores you got on what assignments. You just need to reach out, let me know. They're all custom made. So it takes me about 10 to 15 minutes to make each one for you. But just let me know, if that's what's causing your stress level. And again, if it's something else you need to talk about, just reach out to me and I'll do my best for you. All right. But a lot of us are over here, and that's great. I know. I imagine as we get closer to the end, for some of us, that level's going to keep rising, especially if we're behind. So I got to say, you guys, now's the time. If you're behind, if you're not doing well in this class, now's the time. We gotta scrape it together and get our grades up. And I can help you with that. You need to attend the target sessions at 12:30 and 2:30. You need to ask questions. You need to advocate for yourself, meaning if you don't understand something, if you don't know where to start, you need to be the one that speaks up. It's called self-advocating. Oh, Gina, I'm sorry to hear that. So, yeah, if you need help getting caught up, Gina, let me know. Come to the target sessions, and I can get you started down the path, okay? Remember, guys, there's no penalty for late work, okay? So as long as you get it done and turned in, you can get full credit. You can retake every assignment. All those workbooks, you have unlimited retakes on. The tests and the quizzes, you have up to 3 attempts on, okay? So you have the opportunity to go back through the whole semester and redo everything if that's your prerogative. I hear you, LaChristian. Luckily we record these things. Are you on your way back? No, you're on your way down. You're on your way down, right? This Warren Court, because there's a lot of information. Some of it we really need to know. Some of it's just kind of interesting, but it's a lot of information. All right. So again, yesterday we looked at Roe versus Wade and other court cases that were for women's civil rights. Today we're going to look at just the Warren Court, and it says the Burger Court, but we're really going to focus almost exclusively on this Judge Warren, who we've talked about in the past. So a little background information on him. In 1953, President Eisenhower appointed that California Governor Earl Warren as Chief Justice of the Supreme Court. Remember, he's the governor that ends segregation in California before Brown versus Education and segregation nationwide. So kind of because of how he handles that situation, Eisenhower sees it and nominates him to be the Chief Justice of the Supreme Court. Fun fact, you don't have to be a judge or a lawyer to be nominated for the Supreme Court. They can nominate anybody. And as long as the Senate approves, you can get in. So that's just a little fun snippet. Both of these men were moderate Republicans. So what that means is they were kind of like centrist, just kind of leaning a little bit more towards Republican conservative ship in 1953. We would probably consider both of these men Democrats in today's political climate, honestly. But Eisenhower is going to come to dislike Earl Warren as time goes on because of his legal opinions. Once he picked up the gavel, Chief Justice Warren began making controversial rulings in a number of landmark cases that's going to deeply transform American society. The first being Brown versus Board of Education, which we've talked about a lot before. Remember, this is where those kids who were forced to go to the black school on the other side of town, many miles away from their homes, when there was a perfectly good elementary school right down the street, but it was relegated to whites only. So their parents sued, saying that separate but equal was unconstitutional. And they won. And they won because of Chief Justice Warren sided with them and got other judges to side with them. And they ruled that separate but equal was unconstitutional, specifically in public schools. The court ordered desegregation, but they're going to get a lot of pushback for it. Southern whites who considered segregation their cultural tradition resented the Supreme Court's interference. The Alabama governor, his name is George Wallace. I was going to say his name was escaping me. He ran for president in the 60s, is quoted as saying segregation now, segregation then, segregation today, segregation tomorrow, segregation forever, in regards to the Brown versus Board of Education ruling. But throughout the South, angry mobs are going to gather to oppose the first desegregation efforts. In 1957, a group of students in Little Rock, Arkansas, nicknamed the Little Rock Nine, became the first black students to attend Central High School in Little Rock, Arkansas. And they're going to face extreme adversity from people throwing glass bottles at them, people yelling at them, picketing and protesting outside of the school. And in 1962, a man named James Meredith is going to be the first black man to enroll at the University of Mississippi. In both of these cases, the government is going to have to call in federal officers or the National Guard, military troops, to protect these students and escort them in and out of the buildings because of how violent the crowds are going to be surrounding them, just trying to go to school. So that's going to be like one of the first big cases in the Warren Court. The next is going to be one called Loving versus Virginia. And in the 1950s, the state of Virginia still followed anti-miscegenation laws. Miscegenation, meaning they were anti-interracial marriage. And it was considered a felony for a black person to marry a white person, regardless of gender. It was a felony in Virginia to have an interracial marriage. And in 1958, two Virginia residents, Richard Loving, a white man, and Mildred Jeter, a black woman, who was also of Native American ancestry. God, I cannot speak on today. They get married, but they get married in Washington, D.C. They drive out of Virginia to get married, and they come back to Virginia. When they return, They are awakened and arrested by the sheriff at 2 a.m. They go to court, and the couple pled guilty, hoping for leniency, and they got 1-year prison sentences. The judge, however, agreed to suspend their sentence provided they leave their home state of Virginia and not return for 25 years. So they moved to Washington, D.C. But they were also exiled by their families. Their families kind of disowned them because of this. In 1964, they sought help from the American Civil Liberties Union, or the ACLU, in getting their conviction overturned. And in the case of Loving versus Virginia, it goes all the way to the Supreme Court. Back to our pal, Justice Warren. Lawyers for the state argued that Virginia's miscegenation laws were not unlike laws against incest or polygamy. But the lawyers for the ACLU argued that Virginia's law was based on racism. And in a unanimous verdict, meaning all 9 justices voted, the court declared that Virginia's law was unconstitutional. And in the opinion, Chief Justice Warren wrote, under our Constitution, the freedom to marry or not to marry a person of another race resides with the individual and cannot be infringed on by the state. And again, the Loving case is going to be one of many civil rights issues that the Warren Court helped to advance. So real quick, tell me how you feel about these 2 cases so far. Jerome, good luck, man. So Gina, polygamy is, yes, where you are married to multiple people. So, you might have one guy with like 40 wives or 2 wives, the thruples, So how are you guys feeling on this stuff? Again, if you missed the link, there's the Pear Deck link to log in. Only got about 5 people that dragged their dot. It's actually in some cultures, Larry. It's actually like a show of like wealth and power, and things like that. But I don't know. Chief Justice Warren, Gina? All right, let's move on. So the next case we'll discuss for the Warren Court, in 1962, this is supposed to be the other half of the parenthesis. Apparently I didn't hit shift. It's Engel versus Vitale. And this is going to be revolving around the issue of school or prayer in public school. And in 1962, the issue of school prayer tested the Establishment Clause of the U.S. Constitution. The clause from the First Amendment states that Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. New York State had passed a law that required public schools to begin every school day by leading students in a non-denominational prayer. Any student who objected was allowed to abstain themselves from this daily practice. However, the parents of 10 students disagreed and filed a lawsuit against the school district and the state. The New York courts upheld the law, so the parents appealed the case all the way to the Supreme Court. And the court determined that the Establishment Clause prohibited the government from favoring, endorsing, or promoting one religion over another. Since the public educational system was an extension of the government, it also was bound by the Establishment Clause. Public schools could not promote one particular religion or religious perspective over others by engaging an entire student body in prayer, no matter how non-denominational the prayer. So basically meaning like they could not have a prayer, a Christian prayer. It didn't matter if it leaned towards Catholicism, towards baptism, towards Lutheran, any of Calvinism, any of these Episcopalian, any of these Christian denominations, even if it's a prayer that is non-denominational, just a generic Christian prayer, they couldn't do it because you were basically discriminated against non-Christians in that sense, and it's a separation of church and state argument. Okay. Furthermore, allowing students to remove themselves from this practice served as a way to single them out for ridicule by other students and by staff members. So with two justices abstained from this vote, but the court ruled 6-1 that school prayer is unconstitutional in public school. That's the kicker, guys. So prayer is unconstitutional in public school. Private schools, you have your Catholic schools, your Christian schools, and things like that. It's okay there. Here's a local one, guys, that the Warren Court oversaw: Mapp versus Ohio in 1961. In May of 1957 in Cleveland, 3 police officers were seeking a man named Virgil Ogletree, the operator of an illegal gambling racket. He was suspected of bombing the home of a rival numbers operator named Don King. An informant's tip led the police to a 2-story, like a rooming house, a boarding house type place. When they knocked on the door, a woman, Dolly Mapp, looked out an upstairs window and asked why they were there. The officers requested admittance to search for Ogletree. Mapp called her attorney, who told her to refuse them entry because they had no warrant. One policeman went to the back door and broke the window to open the door. Mapp blocked them and demanded to see the search warrant. An officer waved a folded paper in her face and attempted to push past her. Mapp snatched that paper from his hand and shoved it down the front of her blouse, and a scuffle ensued. The officer reached down Mapp's blouse and grabbed the paper back. It later came out in court that this search warrant was a blank sheet of paper that the police used as a decoy. Mapp was handcuffed by the officers who entered the residence, and when Mapp's lawyer arrived to advise his client, he was prevented from entering the residence. Officers then found nude drawings in the basement of Mapp's residence. Mapp received a felony conviction for possessing obscene material. Mapp appealed her conviction in 1961. In the case of Mapp versus Ohio, it goes to the Supreme Court. And after hearing the arguments, the court determined that the Cleveland police had showed utter disregard for the constitutional safeguards barring unreasonable search and seizures. The police had mishandled this operation by passing off a blank document as a search warrant and allowing officers to physically wrestle a female defendant and then restrain her in handcuffs as they searched her home and prevented her contact with her attorney. In a vote of 6-3, the justices ruled in favor of Mapp and reversed her conviction in 1961. And this court decision is going to ensure protections for citizens against unreasonable search and seizures. Now for the big one. Okay, guys, the big one. This is one. Whenever you go, why do we need to learn this? When are we ever going to use this in real life? I hope you never have to use this. But this is what you do if you get arrested. If you ever get arrested, these are your rights. Anybody ever hear of their Miranda rights? This is why we have them. So while at his home in March of 1963, a man by the name of Ernesto Miranda was arrested by the Phoenix Police Department. Miranda was mentally unstable, already had a criminal record, and he was charged with rape, kidnapping, and robbery. And police interrogated Miranda for 2 hours. Finally, Miranda wrote and signed a confession to the kidnapping and rape of one woman. The police interrogator described Miranda's confession as voluntary and presented it as such in court. Yet at no time was Miranda informed of his rights to counsel or that his confession would be used against him. Miranda was sentenced to 20 to 30 years in prison. Miranda's court-appointed attorney, Alvin Moore, objected to the lack of information given to Miranda. He also protested that his client had no attorney present and was not advised that he needed one. Moore challenged this voluntary confession as involuntary given the pressure of the interrogation. In Moore's view, Miranda had been pressured into incriminating himself without counsel present. Moore filed an appeal to the Arizona Supreme Court, stating that Miranda's confession was not voluntary and should not be admitted, and that appeal was denied. Then he filed an appeal to the Supreme Court, and in 1966, the court reviewed Miranda versus Arizona. And this is a close one. This was a squeaker. In a 5-4 decision, the Supreme Court held that Miranda had been denied his guaranteed rights under the 5th and 6th Amendment. And what are those rights? The 5th Amendment says that you have the right to not incriminate yourself. So if you've ever heard the term, I plead the 5th, it means if you're in court, you don't have to tell on yourself. If you've followed any kind of court case where the defendant doesn't take the stand, right, where they're like, he's not gonna testify, that's because, you know, he's not gonna tell on himself. You don't have to tell on yourself. You can stay silent. The 6th Amendment says that you have the right, if you're accused of a crime, you have the right to have a lawyer present during the interrogation. You don't have to say anything other than, I want a lawyer. And if you can't afford one, the police, the court system, they have to appoint a lawyer to you for free. Okay? Now, they're not going to be probably the best lawyer out there, but they're going to give you legal advice in your situation. The court's decision on Miranda versus Arizona established an important precedent in the legal system. It upheld the defendant's right to an attorney as well as against self-incrimination. This ruling forced the disclosure of a defendant's Miranda rights, the familiar warning issued by police officers when they arrest a subject. So if you've watched any like Law and Order or police shows, you'll hear them say like, you have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to an attorney. If you cannot afford one, an attorney will be appointed for you. You know, yada, yada, yada. So, and that's what I just read. You have the right to remain silent. So, guys, if you ever get in trouble, you don't have to say anything. I hope and pray that you all make good decisions and good choices, and you never find yourself in this situation. But if you do, you have the right to remain silent. You don't have to say anything, because anything you say can and will be used against you. You have the right to an attorney. So if you do find yourself in this situation, just say, I want a lawyer. And if you cannot afford one, one will be provided for you. Please make good choices. Some other key Warren Court rulings. Gideon versus Wainwright in 1963. The Supreme Court ruled that under the 6th Amendment, states are required to provide a defendant with a lawyer if the accused cannot afford one. So that one kind of piggybacks off the Miranda one. And then in Tinker versus Des Moines, the Supreme Court ruled that a student's right to protest and speak at school cannot be infringed unless it causes a substantial disruption. Okay. So you are allowed to protest at school. You are allowed to voice your opinions as long as you are not causing a quote-unquote substantial disruption. All right, and then the exit ticket is quick. Did you find this lesson interesting and challenging? Was it too easy? Was it just right? Or was it too hard? What did you think of today's lesson? Too easy. Somebody. Oh, that was me. All right, guys. And then finally, again, tomorrow, Wednesday, no class. So let's look at today real quick, because I guess I'm getting ahead of myself. Today you got workbook 4.9. Okay. Right here. Some of you have already done it, which is great. Tomorrow you have this MLK quote analysis. Again, read through the instructions. I tried to make them as straightforward as possible. If you don't have to use the sentence stems I've provided, but if you're somebody that has, you have trouble getting started in writing, use these sentence stems. But because you need to write using complete sentences. One-word answers will not get you credit on this assignment. Okay? Neither will copy and pasting from Google. Okay, these are your opinions. So meaning there's no right or wrong answer. And that's what I put here. You got 3 little disclaimers. There's no right or wrong answers. So the way to get credit is justify your opinion. So if you agree, tell me that yes, you agree, but why do you agree? What are those reasons surrounding your agreement with the quote? Or if you disagree, what are the reasons surrounding your disagreement? Justify your answer. Okay. What else? Organize your thoughts into a cohesive paragraph. Okay, paragraphs, guys, not middle school or elementary school. Paragraphs this is high school, 5 to 10 sentences is a cohesive paragraph. Read your classmates' opinions. If you're not sure, read what somebody else's opinion is. You don't have to copy that opinion. I'm not saying that. I'm saying read what somebody else is saying and see if that helps to clarify what you're thinking and not able to get into words, right? Because sometimes we can look at something and we can feel a way about it, but we don't necessarily quite know how we're going to get it out into words. Read what somebody else wrote for that part and see if that helps to clarify. Do not copy it. Also, comment on your, I enabled comments on this. So comment on your classmates' opinions. Let them know if you agree or disagree with what they said and why. Tell them why. Again, guys, the points for this is a 25-point discussion. Points come from following these directions, not from your opinion. Okay, so I'm grading you on if you follow these, if you're following the directions and answering the questions, not based on your answer. Okay. As usual, be respectful of everybody's viewpoints. Somebody might have a different opinion than you, and that's okay. You are allowed to disagree with that opinion. Okay. But please be respectful in your disagreement or agreement. And then, of course, guys, the questions. You agree with the statement, and then the sentence stems are in green. And again, you can use these sentence stems to your heart's content. If you don't need them, don't use them. But if you're somebody that, you struggle getting started or you just need help, getting your thoughts out, please, by all means, use these sentence stems. Okay. Are there any questions? And that's tomorrow. That's all we need to do for tomorrow. All right. And then Thursday, we'll do the second half of the assessment with the primary source analysis, and we'll go over all of that, and you'll have all of class time to work on that. Okay. Any questions, comments, concerns? Anything I can help you with? It's 11 o'clock. You guys have a great day. Don't forget the target sessions at 12:30 and 2:30 if you need help, okay? Reach out if you need an assignment list. I sent out a big mass email, text, call thing to all students who are failing or have a low D and you're missing more than 5 assignments. Okay. All right, guys. Have a great rest of your day. See you all tomorrow.